Afternoon to you, Unit 5. This is the great team from Virginia who will be presenting to you today, and they're happy to be here. Congratulations to Virginia and congratulations to their teacher. And I just wanted to remind everyone, first, let me introduce myself to you. I'm Dr. Marcy Toma, and I'm your facilitator and timer for Unit 5. And I just wanted to remind you that I will be holding up the appropriate time signs to you. And I also will be turning it over to the judges in just a moment. I will mute myself and we do have a lot of students who are participating just viewing today, but we do have 4 students on the 4 students who are participating in Unit 5. And I think we've gone over the rules already. So I'm going to go ahead and turn it over to my judges, and they will begin by introducing themselves to you.
Lovely, thank you. Good afternoon, Virginia. My name is Gus Chin. I'm a municipal judge from Utah.
Hello, Virginia. It's very nice to see you. I'm Matt Gutwein from Indiana. I am retired, but I previously taught constitutional litigation and civil rights at Indiana University Maurer School of Law.
Good afternoon, Virginia. I am Anna Terry Flores. I'm a state senator from Miami, Florida, and I participated in the We the People program, also in Unit 5. And our team won the national competition that year. So I know you all are feeling nervous, but take a deep breath. I know you're going to do really well.
Thank you. Please introduce yourselves and your teacher. Thank you.
Hi, my name is Bella Stevens.
Hi, I'm Eliza Blue.
Hi, I'm Cynthia Mayapin.
Hi, I'm Kapil Iyer. We are Unit 5 from Maggie Walker, and this is our sponsor, Mr. Olmschneider.
Lovely, thank you. The question is number 2 and reads as follows. Quote, a Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference, unquote. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? What are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
Isaiah Berlin wrote that, quote, to manipulate men is to deny their human essence, to treat them as objects without wills of their own, and therefore to degrade them, end quote. In his groundbreaking work, Two Concepts of Liberty, Berlin articulated the idea of 2 different forms of freedom, positive and negative. Negative freedom ensures that the government does not encroach on individual liberties, creating a zone of personal autonomy. Positive freedom allows the individual to act upon their own will. While both forms of liberty are similar in nature, negative ones are far more important to American political culture.
When drafting the Bill of Rights, James Madison was concerned more with what the government could not do rather than what it could do for its people. The First Amendment is a prime example of this, using the phrase, Congress shall make no law to enumerate limits on governmental power. Without these basic negative freedoms, there would be no zone of guaranteed personal autonomy from the government. The 14th Amendment is the most notable example of an establishment of negative freedoms after the Bill of Rights. Through the incorporation doctrine, this amendment extends negative freedom to the state governments.
In Madison's original draft of the Bill of Rights, he applied the equal right of conscience, freedom of the press, and trial by jury in criminal cases to the states. Madison saw a national Bill of Rights as a way to, quote, rouse the attention of the whole community to prevent oppression by the majority. State bills of rights often contain both positive and negative freedoms, unlike the primarily negative National Bill of Rights. They assert positive rights unique to the social and political community of the state. For example, most state constitutions ensure the positive right to an education.
However, states have not always given all citizens an equal opportunity to education, demonstrating the importance of not merely incorporating the negative freedoms of the Bill of Rights, but also ensuring equal protection of positive freedoms under the 14th Amendment's Equal Protection Clause. In the 1787 letter to James Madison, Jefferson also condemned this lack of uniformity that came with state constitutions, particularly with regards to the right to a trial by jury of one's peers. After all, the failure of King George's courts to use a jury of American colonists was a driving force behind the American Revolution.
Jefferson believed that a written Bill of Rights, which applies to everyone and explicitly lists rights, would best protect American freedom. He is correct that fundamental rights must be protected on the national level, but he was wrong in saying that they ought to be explicit and written out. For example, the Fourth and Fifth Amendments show that the most important protections do not proceed from the written text. They are unwritten and implicit. The Miranda rights and the exclusionary rule extend the freedom from unreasonable search and seizure and the privilege against self-incrimination far beyond what the text requires on its face. They are derived from the spirit of the text.
Also, the meaning of the explicit text is unclear. For example, the Katz v. US standard for the Fourth Amendment's unreasonable parameter was developed nearly 2 centuries after the Constitution was ratified. The majority opinion in Katz derived the reasonable expectation of privacy test not from the Fourth Amendment's text, but from the American ideal of privacy implicit in our historical protection of postal confidentiality.
Written bills of rights thus empower the judiciary to shape and interpret fundamental rights without the input of the people. Because the judiciary is intrinsically undemocratic and unaccountable, these interpretations risk becoming arbitrary and unjust. For instance, the perverse decision in Kelo v. New London ruled that the takings clause wording of public use allowed the government to seize land and sell it to the private sector in hopes of, quote, improving the local economy.
After Kelo, public outrage led to several states restricting eminent domain as a way to symbolically protest the court's decision, with 8 passing constitutional amendments limiting eminent domain. The life terms of justices and an immovable salary leave the court invulnerable to the 2 democratic institutions of the federal government. Thus, written bills of rights enable the judiciary to distort society's self-determinable outlook of what constitutes a just interpretation of positive and negative freedoms. Thank you, judges, and we are ready for your questions.
Thank you. The starting point will be where you left off, the judiciary. Now, given the role of judicial review, can you think of instances where the court may not have gotten it right but corrected itself? Or in other words, has the court always gotten it right? You've already hinted at that.
Sure. So one instance, it was the case Minersville versus Gobitis, which was a case in which the court ruled that public schools could compel the saluting of the American flag during the time of the World War II. And they ruled this because they were worried about Jehovah's Witnesses not saluting the flag, and because they believe that God is supreme and not the United States, and they were worried about a foreign interest. However, they overturned this many years later. And while it was a controversial decision that led to the persecution of many Jehovah's Witnesses in America, they did ultimately realize that they were wrong a few years later.
I would also look to the civil rights cases of 1883, where the court looked to the explicit text of the 13th and 14th Amendments to determine that the government cannot ban racial discrimination in public accommodations because the Equal Protection Clause only prohibited state discrimination. On the other hand, Heart of Atlanta Motel v. US in 1964, the court found it in the Article 1 Commerce Clause, not the Bill of Rights, to permit civil rights legislation affecting places of public accommodation. And we can see here how forcing textualism can cause us to have to use very indirect and abstruse methods to secure our individual rights.
Let's follow up on that concept. You've already recognized that a number of our most important individual rights are not found in the plain language of the text. You mentioned Miranda. There are numerous others. Obergefell, where the court recognized the right to marry among same-sex individuals. Can you tell me what principles should the court use when recognizing rights that are not found in the express language of the Constitution?
I would say that the court should strongly emphasize evolving standards of what the American political culture dictates when concerning rights. One example is Trop v. Dulles, where the court did rule that evolving standards of decency prevented certain punishments for crimes that would revoke citizenship. So we see that even in the founding era, if this wasn't necessarily true, in the mid-20th century when that case was decided, the supposed evolving standards of decency compelled the court to recognize this right to have citizenship regardless of committing any crime.
Any other standards, evolving standards? Let me just pick on that a little bit. You've already recognized that there's no federal right to education, but surely this country has evolved to say that education is of the highest value in our country. So evolving standards hasn't satisfied the need to recognize a right for education.
Absolutely. Actually, that's a very brilliant example, Judge, because just very recently, the lower federal courts have ruled in Gary v. Whitmer and Gary v. Snyder that there is a right to education in the 14th Amendment. Now, obviously, they can't compete with the Supreme Court ruling in Rodriguez, so it's not absolute, but they argue in the majority opinion that they can rule against Rodriguez because in this instant, right now in the 21st century, it's a different instance because there's an absolute denial of education to certain ethnic minorities. So we see that as time evolves and we become a more diverse nation, access and equality of education is more important.
I think furthermore, this is a circumstance in which we can look to state constitutions because there is a right to education in almost every single state constitution. And because states are able to interpret their constitutions differently because they have a different text than the national constitution, they are able to provide higher ceilings for what that right may be. So for instance, after the San Antonio v. Rodriguez decision, there were many states that were able to extend their rights to education in the state constitutions to imply a right to equal access to education and a right to an equal education.
Going off of what my colleague said about the states ensuring the right to education, it is, I believe, more important for states to ensure this because it is closer to the local community and allows for that local and state community to have more control over their own area and what they control in education.
Thank you. Let's have Senator ask her question.
Thank you. So you all have done a great job of listing on the rights that are in the Bill of Rights. But are there times when there should be any limits on the rights that are expressed in the Bill of Rights? And if there are, what limits should those be? And how should the court determine which are okay limits?
There absolutely should be limits on the certain rights in the Bill of Rights. For example, the freedom of speech. While speech is obviously extremely important to political culture, there has to be rights on this to ensure the safety of the community. So for example, the Brandenburg test established a test on whether or not speech was considered incitement and dangerous to the community. And that is an example on where the court can limit speech in case it is dangerous.
Yeah. And there's also times when rights conflict with each other, or perhaps they even conflict within themselves, such as the free exercise and the Establishment Clause. But I think another really important question to consider here is when has the right been fulfilled? Because if we're constantly adding limitations, then when has the right not been fulfilled? We shouldn't overly restrict it. I think that an important thing the government should do is to create legislative standards of quality. For example, the Virginia State Constitution first lays out a broad positive right to education, but then has legislated extensive standards of quality, listing out the many criteria and obligations to be met by government to fulfill the positive right in a way not open to interpretation. This method also allows the criteria to evolve over time to the change of society through legislative amendment on behalf of the constituency, yet it only allows restrictions as far as not completely making the right dissolve.
To tie back to your question, negative and positive rights in the Constitution are not absolute. The government does have obligations in certain circumstances to limit things like freedom of speech or freedom of religion in the interest of either, for example, free speech in public schools. In Tinker versus Des Moines, the government was able to place a compelling interest on student education to limit free speech. Or, for example, when we're talking about excuse me, I totally forgot what I said. But when we're talking about limits on other rights, for example, religion, we can discuss vaccines and how there is this religious exemption that some people may view to vaccines. However, there's a compelling state interest in public health in order to mandate vaccines.
Let's just jump on what you just mentioned about negative and positive rights. Are there any negative rights not in the Constitution, the Bill of Rights, that you think should be added?
I think that there are many positive rights that other countries may find, for example, a right to dignity or other freedoms that can be found through a Ninth Amendment reading of the rest of the Bill of Rights. For example, several of the expressive rights in the First Amendment can be interpreted to find other rights that aren't explicitly mentioned in the text.
Right. But in terms of negative rights which prohibit government action, are
I'd
there...
also,
Oh, sorry. Your
It's
thought has
time.
been retained.
Yes,
another time.
it was a great question, Judge, but it is time. And thank you for the great participation from the Virginia team. And congratulations to the teacher. And I'm turning it over to the judges so they can provide some feedback to you.
Lovely, thank you. Very well done, very responsive. I do appreciate the starting point in terms of your opening remarks, the importance of the rights of the individual, how they provide for the individual, they uplift or they can degrade the individual. I do appreciate the authorities that you cited as examples in the course of your response to our follow-up questions. And it's clearly evident that you prepared well because you covered areas which were unanticipated. So lovely job, all of you.
I agree with Judge Chin. That was an absolutely spectacular presentation, incredibly nuanced and subtle in your deep understanding of the Constitution. You're the first team we've heard all day that has recognized the importance of those rights that are not explicit in the Constitution. Miranda, the exclusionary rule, your deep understanding that rights often conflict with one another, and therefore you have to have a hierarchy of those rights because it's not possible to recognize all of those rights. Fantastic use of case law, the Minersville case, Tinker, Brandenburg, just an absolutely complete presentation. Warmest congratulations to each of you, your classmates and your teacher. Really superb and superior job.
I agree. Great job. Everyone participated. You all had great points to make, obviously as a group, but individually as well. And I think that's always nice to see that the teams, you all are you've learned from each other as well. So I think that's really, really great. You cited case law, you cited, examples, not just current examples, but in history, and you took it back to King George and the courts there. I thought that was really great. So again, you did a fantastic, fantastic job. I hope that one or several of you run for office in Virginia or elsewhere, because your state will be very, very proud of you. You did a great job.
Can you remind me of the name of your school?
Maggie L. Walker Governor School.
Yeah, got it.
Thank you so much.
Thank
Thank you for
you.
taking the
Thank
lead,
you.
because
Good luck to you all.
Thank you.